for construction purposes, you need to have clearly defined parties to your contract or your agreement. You need to make sure that those parties have legal capacity to actually enter into contracts. So the client needs to be a bona fide homeowner or owner of the land, or have a legal document that gives them the authority to have the legal capacity to act as, right, that person. And then of course the contractor or the engineer, they also, this is going to tie into this even when we're talking about compensation, they need to have the legal capacity to be qualified and certified and licensed to do what you are hiring them to do. They must have the legal capacity to make the contract binding. All right, the contract should have compensation, should have consideration. That's the price, the quantitative amount or figure included for what is the cost of this transaction. The contract should have a term. How long am I expected to be in relation with you in this transaction? We also recommend that it should have terms within the term, deadlines specified. We also identify certain clauses that are helpful for construction contracts, such as the jurisdictional clause, meaning that it's in Trinidad and Tobago, the clause that speaks about how are we going to settle disputes, right? The resolution clause. We would have spoken about the force majeure clause, and then the clause about what was the next important clause we need in a construction contract? Of course, the scope, right? Yeah. Defining what has to be done, the design, the layout, those kinds of things, to just really make it clear. And of course, reminding and the clause saying that these things are according to the laws of Trinidad and Tobago, not copy and paste from Florida or any other state. And make sure the two parties sign and there's a witness, etc. So that was the legal things that we would have identified for having a proper and sound contract. Reviewed by a legal professional, preferably an attorney at law, to make sure that it is sound, it is binding, and it is effectual in law, meaning that it can actually take effect.
Because if we don't do that, then we can't reach part 3. There will be no legal violations and there will be no compensation. Ms. Daniel, you pointed out some very important points, and to add to what you're saying in terms of construction contracts, and I'm going to talk a little bit from the contractor's position, right? Because a lot of times the contractor is just say, yeah man, I will do that for you, but that is not defined. And so design is important. That is, I have said this for the last 3 weeks. Make sure you know what you are doing. Whether that design is a survey plan of how you're going to cut up the land because you're going to buy the land, or somebody is going to sell you the land. What is their plan? What was the plan for the land? What is the design for the structure? What is the design for the layout? You know, if you're doing a park or you're doing something that may be agricultural, what is the design? Because the design informs somebody like me who is able to quantify things, or professional quantity surveyor who's able to quantify things with a stamp, which goes to the bank. We need to have a design. Don't just say, tell me how much is your house? Yeah, about 3 stories, this big. That would not work. You need to have a bona fide design. The other thing is the design then informs the scope. Are we going to do the entire structure? Are we going to build the roads, the drains, the bridges? Are we going to run the water? The design informs the scope. And once you have a proper scope and a proper design, then you could do what we call a bill of quantities. A bill is almost like a receipt when you go to a restaurant and you took steak and eggs, you took French toast. The bill of quantities says these are the amount of bricks, these are the amount of cement, these are the amount of sand, these are the amount of tie and wire, whatever it is. Those are then put on a bill of quantities, which is all part of your contract, so that as the contractor, you can tell the employer or the client, sir, ma'am, this is what the design gave, this is what the scope said, and this is what I quantified it to be. When the client says, well, just take the wall and just give me a little design in it now. That design needs some, and we'll talk about that today, because what is a legal violation from the contractor's point of view? Can't just be listening to your client without due process. And today, what I really want to hone in on and focus on are two things. One, your change management process. 9 out of 10 times a violation legally has to do with something that changed. And 9.9 times out of 10, something will. So we need to talk about what our change process is, whether the change process is something on the client side or on the employer side or the contractor side. We need to understand what is our change process. So that is how we could move into what is a legal violation, and we could also move into how is the compensation. Now, one of the things that we are scaling up on right now is the FIDIC contract methodologies and contracts, and that's something that we are honing and soon to be very, very qualified and certified in. However, one of the things that of every contract that we need to take into consideration are what we call special conditions. Every contract will have something called special conditions, where if I'm going to build a tank stand for you and I take into consideration the soil is a particular loomy kind of soil, or soil I could take a weight, I don't have to worry about water retention. And for some reason, when we dig on the day, we realize that, hey, this is not what we thought the surface was. There's a lot of water retention here. What is my due course? Do I just say, boy, let me just build it so on and forget them? You know, and a big part of, and Ms. Daniel, I want you to jump in here. Is there, in a contractual situation or in a legal situation, room for a professional being professionally responsible?
Yes, and that is exactly what today's conversation has to be about, based on the topic that we've highlighted. And I'm very excited to get into it, because when we said legal violation, and you have, that will be in two spheres, and then of course the compensation. So for the purpose of this discussion, when we say legal violation, in this context, we're discussing two legal violations: either violation of the contract itself, substantively, meaning some condition or term in the contract or clause was breached, right? So that's a contractual violation, or a professional violation, where a duty of care, right? And so for this evening's discussion, when an individual determines that there is some sort of legal claim involved in a dispute arising from a contract, a construction, or this type of transaction, we need to find out three things, right? Was there negligence?
Correct.
Was there a breach of contract, a breach of warranty, or strict liability? For the purpose of this conversation this afternoon, we're going to stick on those first two: negligence and breach of contract. We have been talking about contract a lot, so I'm going to go with breach of contract first. Then we're going to come back to negligence, because negligence is a very, very serious legal topic. And very specific.
Now, before you jump in, Ms. Daniel, I want to make something very clear. When parties enter into a contract, the violation is not against the parties. The violation is against the contract. And so a lot of times when, and it's very important to demark what it is. I might do something because it might be right. It might be the right thing to do, but it violates the contract or the agreement that we agreed on. And so that is why I spoke about earlier of what is your change management process. Because while you may do something right or good, you may be still in violation of your contract, and therefore due to compensate the other party.
Right. I understand what you mean, Mr. Paul, and you are right up for a point. But however, there are times when you could actually be in violation of the parties too. So I'm glad that you mentioned that, because breach of contract is one thing where there is a legal violation of the contract itself, as you mentioned, right? Whether the act was good or not, sometimes it could actually be that you use less material, or you cost less money, but you still breach the contract if it specifically said $10 and it came in at 8, right? So there's actual breach of the contract. But then there's also professional obligation, and this is where the contractor needs to be aware, because their duty of care. Now, interestingly, I'm going to bring an interesting point about negligence here for the two parties. Because in the event that there arise to be a dispute due to the client not actually being the owner and fraudulently misrepresenting themselves, they may create an entitlement for the contractor. Loss of earnings, wasting of my time. I ended up building something on somebody else's land, and who is going to pay me my money? These things happen. So there is obligations to the parties as well, and there is where we go into the law of tort and negligence. Breach of contract is strictly to the contract itself, to what is written. Negligence is tort, and it is what is entitled.